Hello everyone. NRIs across the world are always concerned for their Indian assets and succession of these assets because of the geographical distance and absence of their successors in India, since their next generation may not be well versed dealing with the Indian legal succession aspects. The best solution to that is to prepare a comprehensive will in India for Indian assets which can ensure smooth transition of these assets during an unfortunate eventuality which may trigger in future. Today, I, CA Rajit Kothari, will discuss the most critical aspects with regard to wills for NRIs in India. The three clinching questions that I will discuss today are: number 1, what are the essentials of a valid will? Number 2, what happens if an NRI dies without a will? Number 3, what is the rationale for an NRI to have an Indian will? What are the essentials of a valid will? Number 1, names and details of the beneficiaries to whom the assets are to be bequeathed. Number 2, signature of the person preparing the will along with the date. Number 3, names and signatures of 2 adult witnesses who were present during the time of preparation of the will. It is also advisable to obtain affidavits of both those witnesses. It is also recommended to get the will notarized in India or in the country of residence of the NRI through the notary public. However, it is not mandatory to register the will. Registration of the will depends on the facts and circumstances of the case. Therefore, an NRI can comfortably prepare a will by residing in his or her country of residence without traveling to India. What happens when an NRI dies without preparing a will? As per the Hindu Succession Act, whenever a Hindu dies intestate, that is, without preparing a will, all his or her assets are equally divided amongst the class 1 heirs, which is, in case of a male, his mother, his spouse, and all his children or heirs of predeceased children, whoever is alive, and in case of a female, her husband and her children or heirs of predeceased children, whoever is alive. What is the rationale of having a will? A will helps in distributing assets as per the wishes of that NRI individual in the manner he or she deems fit. It also helps in faster settlement and transmission of assets after the death of that individual. For any kind of questions regarding to preparation or execution of wills for NRIs, feel free to contact us. Follow us through our YouTube channel Ashutosh NRI Fintechs to remain regularly updated from the world of finance for NRIs.